PVL3702 Law of Contract, Chapter 9 Parties to Contracts. Number 9.1 Number of parties. As contract is based on agreement, and agreement presupposes a concurrence of wills or intentions, there will always be at least two parties to a contract. As noted in earlier chapters, South African law does not recognize a unilateral promise or declaration as a binding contract, and quite clearly a person cannot contract with himself or herself. At any rate, not unless he or she is acting in two different capacities. And then there's a small pause for reflection. A person can contract with him or herself. Despite initial doubts on this point, the courts have accepted that it is possible for a person to contract with him or herself when acting in two different capacities. An example would be where a person acting in his or her capacity as the agent of a corporation concludes a contract with him or herself in his or her personal capacity. Of course, this might lead to a conflict of interests and creates the potential for abuse. For example, a person might by these means create the appearance of a contract in order to avoid liability for tax. In such a case, the courts would disregard the sham contract and give effect to the real underlying state of affairs. Number 9.2 Multiplicity of parties. Most often, there will be two parties to a contract, but frequently there will be more than two. In that event, the provisions of the contract will have to be considered closely to determine the liability and entitlement of each party to the agreement. In this regard, it must be remembered that a contract almost always gives rise not to one but to multiple obligations, and that in respect of each obligation there will be at least one debtor and one creditor. Moreover, the party who is the debtor in respect of one obligation may be the creditor in respect of another obligation due in terms of their reciprocal contract. In the contract of sale, for example, the buyer is the debtor in respect of the obligation to pay the price, but the buyer is the creditor in respect of the obligation to deliver the thing that has been sold. Where there are multiple parties to the contract in respect of each obligation created by the contract, there might be a number of co-debtors or co-creditors involved on either side of the obligation. It then becomes necessary to determine the share of liability of each such co-debtor and the share of entitlement of each such co-creditor. This determination depends on a variety of factors, including the intentions of the parties, the nature of the contract, and the nature of the performance owed under the obligation, in particular whether the performance is divisible or not. Number 9.2.1 Divisibility of the performance. A performance can be either divisible or indivisible. An example of a divisible performance would be where a seller sells 100 cows to two purchasers. An example of an indivisible performance would be where the same seller sells one cow to two purchasers. Whether a performance is divisible or not depends not only on the nature of the performance but also on the intentions of the parties. Thus, where a person sells a collection of rare paintings, intending that they should all be sold together as a collective unit and not individually, the performance is indivisible by reason of the intention of the parties, even though it is physically possible to divide the performance into separate components, namely the single paintings. Number 9.2.2 Simple joint liability and entitlement. Where several debtors are liable to make a performance to a creditor and the performance is divisible, there is a strong presumption that the liability was intended to be joint, rather than joint and several. Simple joint liability means that each of the debtors is liable only for a proportionate share of the performance, and these shares are presumed to be equal. Thus, if the obligation is to pay 5,000 rand and there are 5 debtors, each is liable only to the extent of 1,000 rand. Obviously, this is subject to any contrary indications in the contract. The parties might have intended the liability of the debtors to be joint and several, or that the shares of liability should not be equal. Likewise, where more than one co-creditor is entitled to receive a divisible performance, the creditors are, in the absence of an agreement to the contrary, each entitled to claim a proportionate share of the performance, and these shares are presumed to be equal. Where the creditor releases one of the co-debtors from delivery or repayment of his or her share, this does not automatically release the other co-debtors from the obligation to deliver or pay their respective shares. However, the bargain struck between the creditor and the single debtor might be of such a nature that the intention is to also free the other debtors from liability. A joint debtor who has paid more than his or her share of the debt will probably have no right to recover the excess from the other co-debtors, unless there is an agreement to this effect, or unless the requirements for enrichment liability are satisfied. Number 9.2.3. Joint and several in solidum liability or entitlement. Despite the presumption in favor of simple joint liability and entitlement, the parties to a contract may of course agree expressly or by clear implication that their liability or entitlement should instead be joint and several. This form of liability also applies by operation of law to certain contractual relationships. Partners, for example, are liable in solidum for the debts of the partnership, as are co-signatories of a negotiable instrument. Joint and several liability may also be imposed by statute. The characteristic feature of liability in solidum or joint and several liability is that each co-debtor is liable for the full amount of the debt, and the creditor can accordingly claim the full debt or any lesser amount from any one or more of them. Payment of the full debt by one of the co-debtors discharges the debt completely, with the result that the creditor cannot proceed against the others. Part performance discharges the debt pro tanto, and the creditor can recover the balance from any or all of the co-debtors. Where one of the debtors has paid the full amount of the debt or more than his or her proportionate share, he or she has an automatic right of recourse against the co-debtors to recover their proportionate share of the debt. If he or she takes cession from the creditor of the claim against the co-debtors, it would seem to be settled that he or she cannot recover from any one of them more than that debtor's proportionate share of the debt. Where a creditor releases one of the co-debtors from the debt, the liability of the remaining co-debtors is reduced proportionately. And then there's a small pause for reflection. Joint and several liability is to the benefit of the creditor. The benefit to the creditor of joint and several liability is that he or she may choose to claim full performance from any of the debtors who is financially strong, leaving it to the latter to recover a contribution from the other debtors, some of whom might be financially weak and thus not worth suing. Where a number of creditors are jointly and severally entitled to claim a performance from a single debtor, the same principles apply, with the necessary changes. Thus, any of the co-creditors may claim performance from the debtor, entirely or in part. Performance in full to any one of the co-creditors will discharge the debt. The debtor may choose the creditor to whom he or she wishes to make performance, wholly or in part, unless one or more of them has claimed performance from the debtor, in which case he or she cannot then elect to perform to any of the others. Where a creditor receives more than his or her share from the debtor, the other co-creditors have a right of recourse against that creditor. 9.2.4 Collective joint liability and entitlement. Where co-debtors are liable to make a performance jointly as a collective, the creditor may not demand performance in whole or in part from any one of the debtors individually. And where co-creditors are jointly as a collective entitled to performance from a debtor, no one of the creditors can claim the entire performance or any part of it from the debtor. They have to act collectively. This collective form of liability or entitlement will arise where the performance is indivisible, and the intention of the parties is that the liability or entitlement should be as set out above rather than joint and several. This, for example, where A and B are co-owners of a farm and sell the farm to C. The common intention of all concerned is that C should be able to claim transfer of the farm from A and B together, but not from either of them individually, and that C should not be entitled to claim a portion of the farm from each of them. And likewise, where A and B together buy a farm from C, the common intention is not that they are separate creditors from a proportionate part of the farm, nor that they are entitled in solidum to the farm, so that either could demand transfer into their name. They are collective joint creditors, with the result that they must act jointly in claiming transfer from C. Number 9.2.5. Several liability. In some instances where multiple parties are involved in a deal, for example, when numerous subcontractors agree to complete various phases of works in a construction project, it might be convenient to draft a single document that might contain more than one contract. Care must be taken to interpret this as a document that contains various independent contracts, and not to confuse this with a multiplicity of parties who share in one another's rights and duties. Number 9.3. Contracts and third parties. Although contracts generally create rights and duties only for the immediate parties to the contract, third parties will often be involved in or affected by the process of contracting and its aftermath. For example, third parties might play a role in the formation of the contract, as agents for the principal parties or in the discharge of the obligations created by the contract. Or they might come in as parties to the contract by substitution for one of the original parties, or by the acceptance of benefits offered to them under the contract. All of this is possible despite the hallowed principle of privity of contract. Number 9.3.1. Privity of contract. As noted in Chapter 1, one of the cornerstones of contract is the principle of privity of contract. Being a private transaction, a contract generally creates personal rights and duties only for the parties to the contract, and for nobody else. There are no qualifications to this fundamental principle as regards the imposition of duties on third parties. It would be manifestly unfair if two parties, by their own private acts, could impose an obligation on a third without the latter's consent. However, the principle is to some extent relaxed as regards the creation of rights for third parties, since there is nothing inherently objectionable about two persons agreeing to confer a benefit upon a third. The fact that a contract creates a relationship that is personal to the parties concerned does not mean that third parties have no duty to respect that relationship. An intentional inference in that relationship by a third party might constitute a delict. For example, when A deliberately induces B to break her contract of employment with C so she can immediately begin working for A. So too, in circumstances where the doctrine of notice applies, a third person who acquires property in bad faith might effectively be compelled to discharge a contractual obligation undertaken by his or her predecessor in title. For example, when A buys a farm from B, although A knows full well that B has undertaken to register a servitude over the land in favor of C. Okay, number 9.3.2. Representation, contracting through an agent. Many contracts are concluded not by the principal parties themselves, but through their representatives or agents. This is particularly so when the principal is a juristic person, such as a company. The interposition of an agent can make the relationship between the various parties involved in the contracting process rather complicated. At the outset, however, we need to clarify what is meant by agency, because the term is used in a variety of senses and it overlaps with the concepts of mandate and representation. In the typical agency situation in the contractual sphere, a principal, P, authorizes another person, the agent, A, to represent him or her in negotiating a contract with a third person, 3P. Okay, third person, I guess. A then acting on behalf of P, enters into negotiations with 3P, with the third person. If negotiations are successful, the contract that comes into being is between P and 3P as principals. A, the agent, is not a party to the contract at all, since an agent is a mere conduit. A will have a separate contract with P that governs his or her appointment as P's agent, and that regulates their own relationship. In practice, the term agency is often used to denote A, the contractual relationship between P and A, the contract of agency, or B, the phenomenon of A's representation of P, the agency as a function, or both A and B, in the sense of the law relating to agency. However, care should be taken not to confuse representation with the contract between P and A, for they are distinct legal concepts or phenomena. Representation is the phenomenon that occurs when one person, A, concludes a juristic act on behalf of another, P. This can occur only when A has the necessary authority or power to represent P. This power to represent may be granted by the law itself, usually where P is a juristic person or is someone incapable of managing his or her own affairs, as when a guardian acts for a minor, a director for a company, or a public official for the state. Such cases where the power to represent comes from the law itself are referred to as juristic representation. However, the power to represent may be granted directly by P to A, usually under some contract between the two of them, in which case we talk of conventional representation. In the present context, we are primarily concerned with conventional representation. Then you can just study figure 9.1 on your own time. Where the power of authority to represent is given in writing, it is called a power of attorney. That does not mean, of course, that A is to act as P's attorney. It merely means that A is authorized to perform on behalf of P and acts within the scope of the power. The power of attorney might be a general one, authorizing A to act for P generally, in regard to any matter concerning P, or it might be special, conferring on A limited authority to represent P in a specific matter, for example, in regard to a particular property transaction. Turning now to the contract between P and A, this is often referred to as a contract of mandate, with P as the mandator and A as the mandatory. But this usage can be misleading because not every mandatory is an agent in the true sense. Mandate is a contract in terms of which one person gives another a task to perform. For example, when someone who wishes to sell a house gives a mandate to an estate agent to find a suitable buyer. In this example, there is no true agency involved, because the estate agent is not authorized to sell the property on behalf of the mandator. The mandate is limited to finding a buyer with whom the mandator, him or herself, can conclude the contract of sale. It is only when the contract between P and A includes or is coupled with a power on the part of A to represent P in the strict sense of concluding a juristic act on P's behalf that we are dealing with agency. The contract of agency, this entails both mandate and a power to represent the mandator or principal. The legal consequences of agency are now considered by analyzing the relationships between the various parties. Number 9.3.2.1 Relationship between principal and agent. This is governed largely by the common law principles applicable to the contract of mandate, and is supplemented by terms agreed upon by the parties. It suffices for present purposes to say that the agent occupies a highly fiduciary position and is thus obliged to act entirely in the interest of the principal, and not in his or her own interest. Number 9.3.2.2 Relationship between principal and third party. As regards the relationship between the principal and the third party, the question whether consensus was reached will be determined with reference to the state of mind of A rather than P, since it is A who does the negotiating for P. Moreover, it will be vicariously responsible for the acts of A, in accordance with the principle quae facit per alium facit per se. He who acts through another is deemed himself to act. This P may be held responsible for any misrepresentations made by A, including those made innocently. Within limits, P's knowledge may be attributed to A and vice versa. It follows that, provided A acts within the scope of his or her authority in concluding the contract with the third person, the ensuing contract will be between P and the third person, and both will be bound by it. On the other hand, if A exceeds his or her authority, P will generally not be bound by the agreement, though he or she might be liable on the grounds of enrichment in respect of any benefits conferred under the agreement. In certain situations, however, P will be bound by the contract despite A's lack of authority. Number 1. The first is where P subsequently ratifies the contract, which is permitted only if A had professed to act as an agent, and if P was in existence at the time when the transaction was concluded. Ratification operates with retroactive effect. In other words, A is deemed to have had the requisite authority ab initio. Number 2. The second situation is where P is stopped from denying that A was authorized to conclude the contract. This will be the case where all the elements required for an estoppel are present. P has misrepresented to the third person that A has the necessary authority. The third person has acted in reasonable reliance upon that representation by purporting to contract with P through A, and the third person would be prejudiced if P could successfully deny the existence of the contract. This is known as agency by estoppel. Number 3. In light of the majority decision in the constitutional case of Mokate versus Vodacom Limited, there is now a third situation in which P can be held bound despite the lack of actual authority on the part of A. This is where A had ostensible or apparent authority to represent P, which will be the case when P by words or conduct created an appearance that A had the power to act on P's behalf. In the past, it was considered that the doctrines of ostensible authority and agency by estoppel were synonymous. In other words, that the appearance of authority would bind the principal only if all the requirements for an estoppel are satisfied. However, in Mokate, the Constitutional Court held otherwise. The only element common to both doctrines, said the majority, is the misrepresentation that creates the appearance of authority, and in the case of ostensible authority, this element alone will suffice to bind the principal. Nothing more is required. And then there is a counterpoint. Wallis, writing for the minority in Mokate, disagreed strongly on the juristic nature of ostensible authority, where there is no actual authority. In his view, it was settled law that this was a form of instance of estoppel, which was why it was commonly referred to in judgments and textbooks as agency by estoppel. The approach of the majority, he said, was based upon a misunderstanding of the position in English law, and was inconsistent with the judgments of our courts since the early 20th century, as well as with the views of our textbook writers. Moreover, there was no reason of principle or constitutional imperative that required the adoption of this new approach to ostensible authority. We associate ourselves with this criticism of the majority judgment. Can it really be the law that nothing more is required to bind P than the mere creation of an appearance that A had the power to act on P's behalf? What if, despite the appearance of authority, the third person knew full well that A lacked actual authority? And then that's the end of the counterpoint. Where A does have actual authority to represent P, but contracts in his or her own name, albeit secretly for P, without disclosing to the third person that he or she is acting in the capacity of agent for P, the doctrine of the undisclosed principle comes into play. As one might expect, A is personally liable on the contract. However, in terms of the doctrine, P is permitted to emerge from obscurity and demand performance from the third person, provided that the third person has not already performed to A and will not otherwise suffer prejudice. Conversely, if the third person learns that A was in fact acting for P, the third person may elect to claim performance under the contract from either A or P. But his or her election, once made, is final, in that if P unsuccessfully sues the one, he or she cannot thereafter proceed against the other. In Cullinan versus Noord-Kaap Landse Aardappelkern Moerkwekers Koöperasie, the Appellate Division acknowledged that this imported doctrine is difficult to reconcile with fundamental principles of our law, but the court refused to discard it on the basis that it had been accepted and applied for many years. The undisclosed principle should not be confused with the unidentified principle, where A informs the third person that he or she acts on behalf of P, whose identity he or she refuses to disclose, and the third person is prepared to contract on that basis. Ensuing contract will be solely between the third person and the unidentified principle. Finally, it should also be noted that at common law it is not possible to represent a non-existent principle. This, for example, no one can, as agent, conclude a contract on behalf of an unborn child. In such cases, the contract is void ab initio and cannot subsequently be ratified when the principle comes into existence. This common law rule presented a most inconvenient obstacle to persons wishing to conclude a contract on behalf of a company that they intended or were in the process of establishing. The courts came to their assistance by construing such a contract as stipulatio auditory, contract for the benefit of a third party, the company, before the legislature intervened by creating a statutory exception to the common law rule in the case of pre-incorporation contracts. In terms of the legislation governing companies, it is now possible to contract on behalf of a corporation that is not yet in existence, provided certain requirements are met. The contract will become binding on the corporation only once it has come into existence, and once it has adopted or ratified the contract entered into on its behalf upon incorporation. Number 9.3.2.3 Relationship between agent and third party. In the normal course of events, where A acts in the scope of his or her authority, he or she will incur no liability to the third person. However, if A lacks authority to represent P, or exceeds his or her authority, A may be held liable to compensate the third person for any loss that he or she suffers through the failure of the contract. If A warranted or promised that he or she had authority to bind P, A will be held liable to the third person in contract for breach of warranty of authority, and the damages will be measured according to the third person's positive interest. If A fraudulently or negligently misrepresented that he or she had the necessary authority without warranting this fact, his or her liability is delictual in nature, and the damages are measured according to the third person's negative interest. Before the development of liability in delict for negligent misrepresentation causing economic loss, the courts held that an agent who exceeds his or her authority would be held liable on the basis of an implied warranty of authority. In other words, the agent will be deemed to have given such a warranty. Whether this resort to a legal fiction can still be justified is open to question. Number 9.3.3 The contract for the benefit of a third party, stipulatio auditory. A contract quite commonly contains provisions aimed at conferring benefits on persons who are not parties to the contract. Pension agreements, life insurance policies, and inter vivos trust deeds are important examples of this phenomenon. In the context of privity of contract, the question inevitably arises: how can a person who is not a party to the contract acquire a right to a benefit stipulated in his or her favor? The issue is one that has divided jurists through the ages. The general rule of Roman law was that stipulations in favor of third persons are not enforceable. The Roman Dutch writers rejected this rule, but offered different opinions on how and when the third party acquired the right to the benefit. To some extent, this uncertainty about the proper construction of the stipulatio alterior persists in modern law, at least among the academic commentators. The South African courts have consistently shown a willingness to enforce contracts in favor of third parties and have devised a set of rules that is workable, practical, and fully in accord with the general principles of the law of contract. And then you can just study figure 9.2 on your own time. The law, as stated by the courts, is as follows. Number 1. Two parties, A and B, can validly contract for the benefit of a third person, C, who is not a party to the contract, and who at that stage need not even exist. For example, C might be an unborn child or a company or a trust that is yet to be formed. The one party, A, the stipulants, stipulates the benefit that he or she wishes to be conferred on C, and extracts a promise from B, the promittance, that B will confer the benefit on C, or at least offer the benefit to C. Number 2. In order to constitute a stipulatio alterior, it is not sufficient that the contract between A and B confers some incidental benefit upon C, nor even that the contract is intended to benefit C. What is required is that A and B should intend to create an enforceable obligation in favor of C, obliging B to make a performance to C and giving C a legal right to demand that performance. Number 3. Of fundamental importance is that C acquires a legal right to the benefit only when he or she notifies B of his or her acceptance of the benefit. Before such acceptance, A and B might validly agree to vary or cancel their contract, without the need to obtain C's consent, or A might release B from the obligation to confer the benefit upon C. Number 4. The relationship between A and B will depend upon the terms of their agreement. This A might have to give a reciprocal undertaking to B in return for the latter's promise to confer the benefit upon C. For example, A might have to pay the premium on a life insurance policy contracted in favor of C. Generally, A will have no right to demand performance to him or herself personally. His or her right, pending acceptance by C, is to insist that B should do nothing in conflict with B's promise. It appears that A cannot compel performance by B to C, after acceptance of the benefit by C. Number 5. Once C has accepted the benefit in his or her favor, C acquires an independent right to enforce performance by him or her by B. According to some cases, C becomes a party to the contract, suggesting a trilateral relationship. Others state that C's contract is with one of the other two parties, presumably with B, in view of the fact that acceptance must be communicated to B, and the frequently encountered suggestion that upon acceptance by C, A falls out of the picture altogether. In principle, there can be no fixed pattern, since the rights and duties of the parties and the duration of their various relationships will depend in the first instance upon a proper construction of the terms of the contract, rather than upon rigid rules of law. And then number 6, where the benefit held out to C carries with it reciprocal obligations, for example, where the benefit is the opportunity to purchase property from B. C cannot accept the benefit without simultaneously accepting the obligations that go with it. The law, as stated above, leaves certain points unclear. In particular, what exactly is it that the beneficiary C is required to accept before he or she acquires a right to the benefit? And does that right flow directly from the original contract between A and B, or from a separate contract concluded by C with either A or B? In other words, does the stipulatio alteri involve one or two contracts? There are a number of views in this regard. The construction that enjoys the most support in the case law and the literature is that the stipulatio alteri in reality consists of two bilateral relationships, one between A and B and another between B and C. In terms of the former, the permittance, B, is under a legal duty owed to the stipulants, A, to make an offer to the third party, C, or perhaps to keep open for possible acceptance by C the offer of the benefit that is implicit in the terms of the contract between A and B. Upon acceptance of the offer by C, the second bilateral relationship comes into being between B and C. Whether thereafter the relationship between A and B continues to exist or is discharged by B having made the offer to C will depend upon the proper construction of the contract. If it is a complex contract entailing other obligations apart from one to make an offer to C, the relationship between A and B will persist after acceptance by C. An older alternative construction favored by some writers was that the stipulatio alteri entails just one contract between A and B, and that C's right to the benefit springs directly and immediately from this contract, rather than from any act on C's part. However, the right thus created for C is inchoate or conditional, in the sense that, although already in existence, it will become enforceable only upon acceptance by C. Until such acceptance, A and B may agree to rescind their agreement, thereby extinguishing C's inchoate right. Accordingly, what C accepts is not an offer in the ordinary sense, but rather the benefit or the right to the benefit, and such acceptance merely serves to confirm and complete the rights of the third party. This alternative construction, strongly advocated by the influential Professor J.C. de Wet, has never found much favor with our courts, though it accords quite closely with the construction of third-party contracts favored in Europe. As mentioned earlier, the proper construction of the stipulatio alteri is an issue that has been debated by eminent jurists for many centuries. The debate continues in our law today. The issue of when exactly the third party acquires the right to the benefit is relevant not only to the general law of contract, but also in the law relating to insolvency, succession, insurance, and cession. And then there's a pause for reflection. The debate about the proper construction of the stipulatio alteri has practical legal consequences. Consider, for example, the situation where a third-party beneficiary goes insolvent after the benefit has been stipulated in his or her favor, but before he or she has accepted it. If the right to the benefit is acquired only on acceptance, it will not fall into the insolvent estate. The opposite will be true if the right is acquired without the need for any acceptance on his or her part. The idea that a third party can acquire a contractual right directly from a contract concluded between two other parties without the need for any act of concurrence on the third party's part is difficult to reconcile with basic contract principles, focused as they are upon consensus and the bilateral nature of the contractual bond. Construing the stipulatio alteri as an agreement that embodies or gives rise to an offer to the third party, which upon acceptance creates a further legal bond and brings the third party into a contract with one or both of the first two parties, is very much more in line with traditional contract thinking. Nor does this more traditional construction leave the third party entirely without legal protection prior to acceptance. If, for example, the permittance fails to extend the offer to the third party or otherwise endangers his or her interests, the stipulants may compel the permittance to abide by his or her obligations in terms of the contract between the two of them. Number 9.3.4. Transfer of rights and duties to a third party. A party to a contract may wish to transfer the rights and duties that he or she has obtained under the contract or some of them to a third party. This is possible but usually requires the consent of the other party to the contract. Contractual rights are transferred by means of a transfer agreement known as cession. Cession entails a substitution of creditors. The right that the creditor has against a debtor is transferred to a third party who becomes the creditor in his or her place. For present purposes, it suffices to note that cession requires the consent of the transferor of the right, the cedent, and the transferee, the cessionary, but not of the debtor. Contractual duties may effectively be transferred to a third party through a process called delegation. Delegation entails a substitution of debtors and requires the consent of all the parties concerned: the creditor, the original debtor, and the third party as the new debtor. The traditional view is that such a delegation will always involve a novation, that is, the extinction of the original debt and the creation of a new one in its place. More recently, it has been held that a contractual debt can be transferred to a third party without a novation, but this matter remains somewhat uncertain. Where a party to a contract wishes to withdraw and be substituted by a third party, this can be achieved either by a complete novation of the contract, that means the original agreement is terminated and replaced by a new one with different parties, or by transferring all the parties' rights and duties under the contract to a third party. In other words, by a combination of cession and delegation. This process is commonly referred to as assignment and is effected by means of a tripartite agreement between all the parties concerned. Number 9.3.5. Performance by a third party. A third party may sometimes intervene in a contractual relationship between others by making a performance that is owed by one of the parties to that contract. For present purposes, note only that by such intervention, the third party does not become a party to the contract in question. Number 9.3.6. Performance made to a third party. If the parties to a contract agree, the debtor may discharge his or her obligations by making his or her performance to a third party, the so-called adiectus solutionis causa. Such third party is merely added for the sake of payment, unlike the third party beneficiary under the stipulatio auditory. He or she does not become a creditor in his or her own right, with a right to demand performance from the debtor, nor may he or she claim performance on behalf of the creditor, since he or she is not the latter's agent. PVL3702 Law of Contract, Chapter 10. Obligations and Terms. Number 10.1. Introduction. The preceding chapters deal with the requirements for a valid contract and the parties to a contract, whereas this chapter involves the subject matter of a contract, or rather the obligations to which a contract gives rise and the terms that determine or qualify the obligations in some or other manner. Much of the content of a contract is determined by the contracting parties themselves, but terms are also derived from the operation of law. Number 10.2. Obligations. An obligation is a legal bond between two or more persons. It comprises both a right and a duty. The debtor bears a duty to make the performance agreed upon, and the creditor has a right to claim that performance. All contractual obligations give rise to personal rights and duties. In other words, the right arising from a contractual obligation is only enforceable against the other party to that obligation. This can be contrasted with a real right, which is enforceable against the world at large. Number 10.2.1. Classification of obligations. Obligations may be classified in various ways. These classifications overlap. In other words, an obligation may simultaneously fall into several categories. For example, an obligation relating to delivery of a table lamp might be civil, simple, and reciprocal obligation, as well as entail an indivisible performance. Number 10.2.2 Civil, natural, and moral obligations. Obligations may be moral, civil, or natural. A moral obligation, such as the duty to fulfill a promise to meet a friend for coffee, is not regarded as a legal obligation and has no legal significance at all. It is merely a duty that derives from a social agreement or from the dictates of one's conscience. A civil obligation, on the other hand, is a legal obligation that is enforceable by a right of action. Most obligations arising from contracts are civil obligations. If such an obligation is not fulfilled, the creditor may sue the debtor for breach of contract. Natural obligations are relatively unusual. They arise, for example, when a minor concludes a contract. The other party, assuming that he or she is a major or a juristic person, will be bound by a civil obligation, but the minor will only be bound by a natural obligation. Another example of a contract giving rise to a natural obligation is a betting agreement or wager. A natural obligation may not be enforced in a court of law, but it is not without legal significance. Thus, for example, a natural obligation may be set off against a civil one. Similarly, if someone makes a performance owed in terms of a natural obligation, he or she may not later reclaim the performance on the basis that it was unowed. In other words, although the person may not be sued for performance, if he or she performs, such performance will be regarded as having been owed. Number 10.2.3 Reciprocal obligations. Most contracts give rise to reciprocal obligations. In other words, they create at least two obligations relating to two performances that are linked, in that one performance is owed in exchange for the other. In a contract of sale, therefore, payment of the purchase price and delivery of the object of the sale are owed in exchange for each other. The purchaser, therefore, does not have to pay unless the seller delivers. A contract of lease also creates reciprocal obligations. The obligation to pay the rent is linked to the obligation to let the premises. It must be remembered that where there are two obligations, there are two rights, two duties, and therefore two creditors and two debtors. In a contract of sale, the purchaser is simultaneously a debtor and a creditor. The purchaser is a debtor in that he or she owes a performance, that is, payment of the price, and a creditor in that he or she has a right to claim performance, that is, delivery of the subject matter of the sale. The seller, too, is both a debtor and a creditor. He or she is a debtor because he or she owes a performance, the delivery, and also a creditor because he or she can claim a performance, that is, payment from the other party. Number 10.2.4 Simple, alternative, generic, or facultative obligations. Contractual obligations may be simple, alternative, generic, or facultative. Most obligations are simple, in that the parties, when they conclude the contract, specify the exact performance to be made. For example, the parties agree that the seller must deliver a car with registration number CA123456 to the purchaser. Where the parties agree that someone can choose a performance from two or more specified alternative, they have concluded an alternative obligation. For example, the seller must deliver the cow Annabelle or the cow Bluebell to the purchaser. The party with the right to choose could be the debtor, the creditor, or even a third party. If the parties do not specify which party has the right to choose, the debtor will be given the choice. The alternative must be spelled out. Otherwise, the obligation could be void for vagueness. For instance, where a clause gives the debtor absolute discretion to choose to make any performance he or she wishes. Once the relevant party has chosen one of the performances, the obligation becomes a simple one. The debtor is then obliged to make the chosen performance, Thus, if the seller chooses to deliver Annabelle to the purchaser may only demand delivery of Annabelle. A generic obligation, on the other hand, is one that allows a party to choose a performance from a specified genus or family of performances. The party must specify who is to make this choice. Failing this, the debtor will have the choice. The parties must also specify the number or quantity to be delivered. For example, the seller must deliver 3 Nguni cattle to the purchaser. A facultative obligation specifies the performance owed by the debtor, but gives him or her the right to choose to make a different specified performance. For example, the seller must deliver the cow called Annabelle to the purchaser, but he or she may, if he or she wishes, deliver Bluebell instead. At first sight, this looks like an alternative obligation. The main difference between alternative and facultative obligations lies in their enforceability. Whereas a creditor to an alternative obligation may claim whichever of the specified performances has been chosen by the person entitled to make that choice, a creditor to a facultative obligation may only claim the first specified performance, that is Annabelle, and never the other, which would be Bluebell. Number 10.2.5 Divisible or indivisible performances and contracts. Contractual performances may be either divisible or indivisible, which in turn affects the number of obligations to which a contract gives rise. An obligation is a legal relationship between a creditor and a debtor in respect of a specific performance. If a contract relates to more than a single performance, more than one obligation is created. Therefore, there are as many obligations arising from a contract as there are distinct or indivisible performances owed in terms of it. A divisible performance can be divided into more than one performance, each performance capable of being meaningfully performed on its own, whereas an indivisible performance cannot. Whether a performance is divisible or not depends first of all on its nature. Thus, a performance consisting of building a shopping center is divisible into separate parts such as preparing the land, erecting the building, installing electrical wiring, tiling, painting, and plumbing. Each distinct performance notionally gives rise to a separate obligation. A performance consisting of the delivery of a horse, on the other hand, is by nature indivisible, and gives rise to a single obligation. Note, however, that the contract of sale in respect of the horse gives rise to two distinct performances and hence two obligations. The obligation on the part of the seller to deliver the horse and the obligation on the part of the purchaser to pay for it. If a performance is by nature indivisible, there is no need for further inquiry. If, however, it is divisible by nature, one has to ask an additional question. Did the parties intend the performance to be divisible? The classic example is a performance consisting of delivery of a pair of horses. This is by nature divisible, in that each horse could be delivered separately. However, it may be that the parties intended the pair of horses to be regarded as a unit, and therefore that the performance should not be divisible. Just as performances may be divisible, so may entire contracts. A divisible contract is one that can be divided into separate contracts, each contract having one or more obligations. Thus, if a contract is divisible, it is as if the parties have concluded several distinct contracts. Firstly, the requirements of validity must be satisfied by each divisible part of the contract. For example, if only one of the parts does not meet a formal requirement, that part of the contract will be void and the rest will be valid. Secondly, the rules relating to breach of contract apply to each part of the contract. Thus, if a party breaches part of a contract that is divisible, the aggrieved party might have the right to cancel only that part of the contract. Number 10.3 Terms. Terms are firstly the stipulations that the parties include in their contract, and secondly, provisions that by operation of law are included in contracts. Cumulatively, these terms constitute the content of the contract and in turn give rise to the legal consequences or obligations arising from the contract. Within permissible limits, the parties are free to determine the terms of their contract. Nonetheless, it is possible to classify contractual terms with reference to their nature and effect. Contractual terms may also be classified in various ways, as with the classification of obligations. These classifications may overlap. For example, one and the same term may be an incidentalia, an express term, and an exemption clause. Number 10.3.1, and please forgive my Latin, essentialia, naturalia, and incidentalia. Contracts do not have to fall into any particular category, such as sale, lease, deposit, or loan, to be valid. As long as the general requirements for contract validity are met, it does not matter what name is given to the contract in question. That said, our law has inherited certain traditional types of contract, each with its own set of special rules and consequences. In order to decide whether these rules and consequences apply to a contract, we have to be able to determine whether the contract falls into the category in question. That is, whether it can be identified as a sale, lease, deposit, loan, or any of the other specific contracts recognized by our law. Essentialia are those distinctive terms used to identify or classify a contract as one of the specific contracts recognized by our common law. Consider what makes a contract of sale. A sale is essentially a contract in terms of which the seller transfers property to the purchaser in exchange for money. The essentialia of a contract of sale are therefore terms stipulating that property must be delivered and that the purchase price must be paid. The essentialia of a contract of lease, on the other hand, are terms that stipulate that one party is allowed to use the property owned by another in exchange for payment of rental. Naturalia are terms automatically included in any contract belonging to one of the classes of specific contracts traditionally recognized by our law. They can therefore be said to be implied by law. Ex lege. Naturalia have several advantages. For example, they are convenient in that the parties do not have to negotiate and agree upon them. Also, they often serve to protect one of the parties from a hazard typically associated with that type of contract. For example, one of the naturalia of a contract of sale is that the seller will be liable for latent defects. This protects the purchaser from being sold something that has defects that are not immediately apparent. Another example would be the landlord's tacit hypothec, which protects the landlord from a tenant who does not pay his or her rent. This term allows the landlord to attach the property of the tenant until the tenant pays any outstanding rent. At first sight, the automatic inclusion of contractual terms seemed to limit the parties' freedom of contract. This is not so, however, as the parties may generally exclude these terms by express agreement. Thus, for example, the parties to a contract may exclude the seller's liability for latent defects. Indeed, such exclusion in contracts of sale are so common that they have a special name, voetstoots clauses. By allowing the parties to exclude naturalia, the law attempts to strike a balance between protecting the parties from the most common dangers associated with particular contracts on the one hand and protecting their freedom of contract on the other. The problem with allowing these exclusion or exemption clauses, as they are called, is that they are often abused by the stronger party in situations of unequal bargaining power, exposing the weaker party to the very risk that the naturalia are designed to obviate. The courts have responded by interpreting such clauses narrowly, or contra proferentum. This protection is limited, however, in that the court has the discretion to do so only has the discretion to do so in cases of ambiguity. If an exclusion clause is clearly and unambiguously drafted, the court must apply it. The courts have not assumed the power to strike down such clauses. Moreover, any relief provided by the courts cutting down on the ambit of an exclusion clause by means of interpretation is only available to a party who engages in litigation. In this regard, it must be borne in mind that many contracting parties who agree to harsh exclusion clauses because their bargaining power is weak also cannot afford costly litigation. The legislature has therefore intervened to prevent certain exclusions. For example, the National Credit Act prohibits parties from including a term in a credit agreement that purports to exclude any common law rights that would otherwise be applicable. Similarly, according to the Consumer Protection Act, a supplier is forbidden to exclude liability for any damage to the thing sold caused by gross negligence. Incidentalia are the terms other than the naturalia and essentialia. They are the additional terms agreed upon by the parties that supplement or modify the rights and duties incorporated by law into the particular contract in question, namely the naturalia. For example, in a contract of sale, the parties might agree that the purchaser should pay a fee for delivery, or that the purchaser pay interest on the purchase price if it is not settled in full by a particular date, or that the seller be exempted from liability for latent defects. Number 10.3.2 Express terms. Express terms are terms specifically agreed upon by the parties and are either articulated in an oral contract or written down. The parties might not reduce their agreement to writing at the time of contracting. One party may present the other with a document that has already been compiled, leaving him merely to sign or to fill in blank spaces in the document before signing. Alternatively, the parties might reach an oral agreement and only later put the terms of the agreement into writing. Unless the party intends otherwise, the contract will generally come into being not when the written document is signed, but at the moment the parties reach consensus, or when one party reasonably relies on the appearance of consensus. However, if writing is a formal requirement for validity, the contract will only come into being when its terms are reduced to writing and the document is signed. Number 10.3.2.1 Signed contracts. The caveat subscriptor rule. A party who signifies his or her assent by signing a written contract is ordinarily held bound by its terms, whether or not he or she has read or understood them. This rule is reflected in the Latin maxim, caveat subscriptor. Let the signatory beware. This rule protects the reliance interest of the other party, to permit a party to escape from a contract on the basis that he or she did not bother to find out to what he or she was committing him or herself would also seriously jeopardize commercial relations. As was explained in an earlier chapter, however, the signatory can escape liability in situations of useless error regarding the contents of the contract, the nature of the contract, or the identity of the parties, or where the party unreasonably relied on the appearance of consensus suggested by the fact that the document was signed. The law thus balances the need for legal and commercial certainty with the interests of a party who signed a document in error. A signatory may also escape liability if his or her consent was tainted by misrepresentation, duress, undue influence, or commercial bribery. In this way, the law finds a balance between the often competing policies of certainty and fairness. Number 10.3.2.2 Standard form contracts. Express terms in standardized contracts, also called imposed terms, are in one important respect dealt with differently from express terms negotiated by the parties. Standardized contracts, also called standard form contracts, are commonly used by large corporations and public utilities. They are frequently complex and are not read or understood by the party to whom they are presented, and usually their terms are non-negotiable. A party presenting a standardized contract to another for signature is expected to draw attention to any term one would not expect to find in such a contract. If this is not done, the party sought to be held bound might successfully contend that since he or she had not expected such an unusual term, it does not bind him or her. Number 10.3.2.3 Unsigned documents. Express terms need not all appear in the document that records a contract between parties, but they may be incorporated into the contract by reference. That is, by referring to terms that are to be found in some other document that may not necessarily be signed by the parties. For instance, in the case of an insurance contract, the parties may sign a contractual document containing material provisions such as what the insurance specifically relates to and the premium, but the document will usually also refer to the insurer's standard terms and conditions contained in a separate unsigned document and provide that they be incorporated into the contract. Number 10.3.2.4 Ticket cases. Incorporation of an express term by reference occurs in the so-called ticket cases, where a ticket refers to terms that are recorded elsewhere and the person purchasing the ticket, the customer knows or ought to have known that there is writing on it, and that the writing refers to contractual terms to be found in another document. He or she is bound by those terms, just as if they had been set out in the contract. If he or she did not know that there was writing on the ticket or did not know that the writing referred to extraneous terms, he or she will still be bound if the issuer of the ticket did everything reasonably necessary to bring the existence of the terms to the customer's attention. Once the ticket issuer has done this, he or she may infer from the customer's conduct in going ahead with the transaction that the latter has either read and assented to the terms or is content to be bound by them anyway. These rules, adopted from English law, are usually formulated as a series of questions. Did the customer know that the ticket contained writing? Did he or she know that the writing comprised contractual terms? If these two questions are answered in the affirmative, the customer will be bound by those terms, even if he or she did not understand the import of those terms. If either question is answered in the negative, then a further question is asked. Did the other party take reasonable steps to bring the terms to the notice of the customer? If the answer is yes, then the customer will be bound by the terms. And then there's a small pause for reflection. Do ticket cases need special rules? Is it necessary for our legal system to have special rules to deal with cases such as these? Would it not be preferable just to apply the general rules relating to consensus and reasonable reliance? And that's the end for the pause for reflection. What steps are reasonably necessary to alert a customer to the existence of terms incorporated from elsewhere depends heavily on whether the documents handed to him or her may be expected to refer to contractual terms. In the case of an airline, train, or bus ticket, or tickets such as those admitting spectators to a sports event, everyone is taken to know that they may and probably do incorporate contractual provisions. This is not so in the case of documents such as invoices or warehouse receipts, which do not usually contain contractual provisions and, moreover, which usually have no contractual effect, since they are only handed to the customer after conclusion of the contracts to which they relate. Number 10.3.2.5 Notices. A similar type of express term is that to be found in notices, usually a so-called exemption or owner's risk clause, excluding liability for negligence on the part of the provider of a service. These notices are commonly posted up in parking garages, shopping centers, and other public venues. Under the common law, provided that they are suitably worded, they serve to exempt a service provider from liability for negligence but are, on public policy grounds, ineffective in protecting a service provider against liability for fraud. The person making use of a service will be bound by the terms of the notice if he or she was in fact aware of it, or if it was so conspicuously displayed that it can be inferred that he or she must have been aware of it. If he or she was not aware of it, the provider of the service may still escape liability if it can be shown that he or she did all that was reasonably required to ensure proper notice to the user of the service. The rules that are applicable are the same as those that apply in the ticket cases. Notices and ticket cases are in fact treated as two species of the same genus. An exemption clause is often strictly construed. This means, provided the wording permits such an interpretation, it is given minimum effectiveness, being interpreted so as to exempt the giver of the notice from the least degree of blameworthiness, usually ordinary, not gross, negligence. Number 10.3.2.6, the Consumer Protection Act. The Consumer Protection Act aims to protect the consumer by providing that his or her attention must be drawn to certain categories of clauses or notices that could be prejudicial. This includes notices or contractual provisions that limit the supplier's risk or liability, or that indemnify the supplier or any other person for any cause. This would cover a notice in a parking garage stating that the car owner indemnifies the garage owner for any damage inflicted on the car while on the premises. Similarly, it would conclude a clause limiting the liability of a hospital for negligence on the part of its employees. The consumer must also be alerted to any clauses in terms of which he or she is to assume risk or liability or acknowledges a particular fact. Consumers who enter a shopping center should thus be alerted to a notice at the entrance stating that consumers entered the premises at their own risk. Similarly, a store must draw its customers' attention to a clause in terms of which a purchaser acknowledges that the seller has not made any representations prior to conclusion of the contract. The provision or notice must be expressed in plain language. The consumer must be alerted to the notice or provision before he or she enters into the contract, or before he or she is expected to pay for the goods or services in question, whichever happens first. Thus, it would not be permissible for a store to print a clause limiting its liability on the back of a receipt given to customers after payment. Finally, the consumer must be alerted to the notice or provision in a conspicuous manner and form that is likely to attract the attention of an ordinarily alert customer. Having regard to the circumstances, and the consumer must be given sufficient chance to understand it. The Act goes even further with regard to situations involving serious or unexpected risks to the consumer. It lists these situations as being those where the provision or notice relates to any activity or facility that is subject to any risk of an unusual character or nature, or the presence of which the consumer could not reasonably be expected to be aware or notice, or which an ordinarily alert consumer could not reasonably be expected to notice or contemplate in the circumstances, or that could result in serious injury or death. In such circumstances, in addition to the supplier's complying with the above requirements, the consumer must indicate his or her assent to the clause or notice by signature or by otherwise acting in a manner consistent with acknowledgement of the notice, awareness of the risk, and acceptance of the provision. Number 10.3.2.7, terms prohibited by law. Parties to a contract are not free to agree to whatever terms they choose. A term in a contract that is immoral or contrary to public policy will not be enforced. Thus, for example, it is not permissible to exclude liability for fraud. There is, on the other hand, no requirement that contractual terms need be fair. Depending on the legislature's intention in prohibiting or penalizing an act, a term that conflicts with the statutory prohibition may be invalid. Generally speaking, where an act is prohibited on pain of a penalty, the transaction is a nullity. However, the consequences of nullity are sometimes so grave that it may be concluded that the legislature did not, in addition to imposing a penalty, also wish to make performance of the act null and void. Sometimes, however, courts are given power to modify terms seen as objectionable. The Conventional Penalties Act is an early example of a statute allowing a court to modify the contractual terms between the parties. A penalty clause or conventional penalty typically requires one of the parties to pay a certain sum to the other in the event of breach of their contract. Such clauses have always been allowed in our law, but in view of their potential for injustice, they have at all times been subject to certain limitations. For example, the amount claimable has been capped, or courts have had a discretion to lower the sum in cases of inequity, or such clauses have only been allowed if they amounted to a genuine attempt to estimate the amount of damages that would be payable in the case of breach, as the common law, modified by the courts, was seen to be unsatisfactory. The legislature provided that if, upon the hearing of a claim for a penalty, it appears to the court that such penalty is out of proportion to the prejudice suffered by the creditor by reason of the act or omission in respect of which the penalty was stipulated, the court may reduce the penalty to such extent as it may consider equitable in the circumstances. Number 10.3.2.8 Tacit Contracts. Tacit contracts are contracts that are inferred from the conduct of the parties. Some writers are of the opinion that terms expressed by conduct may nevertheless also be regarded as express terms. A fairly common example of a tacit contract is where, upon the expiry of a lease, the lessee remains in occupation of the premises and the lessor continues to accept rent from the lessee. In such circumstances, a new contract is inferred from the conduct of the parties, irrespective of whether they applied their minds to its conclusion. Tacit contracts are problematic in regard to their conceptual basis, as well as the appropriate test for determining such a contract. Christie suggests that they are not based on reasonable reliance, but rather on actual consensus as inferred from the proven facts. The problem is that tacit contracts have been found to exist where, on the facts, it seems as if at least one party was laboring under a material mistake, which negates actual agreement between the parties. The reliance theory has also, on more than one occasion, surfaced within this context, suggesting that tacit contracts are in fact a manifestation of objective approaches to contractual liability. Likewise, the appropriate test for determining the existence of a tacit contract is fairly controversial. In fact, two tests have been propounded by the courts. The traditional or majority statement of principle was formulated by Corbett in Standard Bank of South Africa Limited versus Ocean Commodities Incorporated as follows. In order to establish a tacit contract, it is necessary to show by a preponderance of probabilities unequivocal conduct which is capable of no other reasonable interpretation than that the parties intended to, and did in fact, contract on the terms alleged. It must be proved that there was in fact consensus ad idem. This formulation coincidentally also advocates a subjective approach to contractual liability based on actual agreement. But in Joel, Malamed and Hurwitz versus Cleveland Estates Proprietary Limited, an alternative formulation was acknowledged in the following terms. In this connection, it is stated that a court may hold that a tacit contract has been established where, by a process of inference, it concludes that the most plausible probable conclusion from all the relevant proved facts and circumstances is that a contract came into existence. This alternative statement of principle also suggests a more objective approach to contractual liability. In this result, competing tests for determining tacit contracts exist in case law, with no resolution apparent as yet. And then there's a small pause for reflection. Tacit contracts present conundrums. Are tacit contracts based on actual consent, or should they more appropriately resort under contracts that are imposed on the basis of objective considerations? Furthermore, do tacit contracts, which are engendered by conduct, really belong to the category of contracts having express terms. Number 10.3.3. Implied terms. Implied terms are those terms not explicitly agreed upon by the parties, but which nevertheless form part of the contract. They may be implied by operation of law, by custom or trade usage, or from the facts surrounding the agreement of the parties, that is, ex consensu. Number 10.3.3.1. Terms implied ex lege. A term implied ex lege is one imported into a contract by law and operates unless the parties exclude it, something that they are usually but not invariably permitted to do. As the law incorporates these terms into a contract regardless of the will of the parties, they may be regarded as imposed terms. As Corbett said in Alfred McAlpine and Son Proprietary Limited versus Transvaal Provincial Administration, in a sense, implied term is, in this context, a misnomer in that in content it simply represents a legal duty, giving rise to a correlative right, imposed by law, unless excluded by the parties, in the case of certain classes of contracts. It is a naturalium of the contract in question. Such implied terms regulate the many incidents of a contract that the parties may say nothing about or may not even know about. In a contract of sale, for example, the obligations of the seller and the buyer are extensively regulated by legal rules that apply unless the parties agree that they should not. Similarly, in contracts of lease, it is usually not necessary for a tenant to stipulate the duties of the landlord, or for a landlord to set out the duties of his or her tenant. For the law provides what their obligations are and how they are to be performed. Terms implied ex lege may derive from the common law, as developed by the courts, or from statutes. Terms implied by the common law. Certain terms are incorporated into all contracts of a particular class. Such terms have already been discussed in the paragraphs dealing with naturalia. Other examples include the employee's duty to act in good faith in relation to his or her employer, and the employer's duty to remunerate an employee, a borrower's duty to return to the lender whatever was lent, an innkeeper's liability for the theft of a guest's belongings, a purchaser's right to restrain the seller of a business with goodwill from subsequently canvassing the business's customers, and the right of a party to terminate an indefinite contractual relationship on reasonable notice. There is no numerous clauses, that is, a closed list of naturalia. The courts may therefore add to the list. Thus, in Murray versus Minister of Defence, the court held that all contracts of employment contain an implied term to the effect that the employer has a duty to deal fairly with employees. Subject to some statutory exceptions, parties are generally allowed to exclude naturalia by agreement. However, in cases of ambiguity, the courts may adopt an interpretation that favors the party who did not formulate the exclusion clause. Terms implied by statute. By imposing naturalia, the common law seeks to protect parties against hazards usually associated with certain types of contract. Obviously, with changes in society and commerce, parties may be exposed to new hazards. For example, when most contracts were individually negotiated, parties were more likely to know and understand the contents of their contracts. Now there is a mass contracting usage, standardized forms drawn up by lawyers, and parties are in danger of being bound by terms that are well nigh incomprehensible to a lay person, or that do not appropriately reflect the actual agreement between the parties. With the increasing use of the internet and telephone text message, it has also become easier to enter into contracts than in the past, and consequently also easier to fall prey to the unscrupulous. The legislature has therefore intervened in areas where the common law was seen to be deficient or out of step with modern conditions. In some cases, legislative intervention has been extensive, such as in the field of labor law. There is an area where contracting parties were seen to be an imbalanced power relationship, and where relatively untrampled freedom of contract had frequently resulted in unfairness to employees. Contracts of employment generally contain terms implied from the Basic Conditions of Employment Act. Unless the parties agree on terms that are more favorable to the employee, the Act's basic conditions relating to matters such as working hours, leave, and remuneration will form part of the parties' contract. Some of these terms may be varied by agreement of the parties and others may not. The common law contract of employment has thus been greatly circumscribed by statute. Another context in which unequal bargaining power has led to inequitable contracts and in which the legislature has sought to protect the weaker party is that of credit agreements. Credit agreements are not historically recognized as a special category of contract, but in South African law, legislation specifically governing such contracts was enacted as early as 1942. The current legislation, that is the National Credit Act, has a far wider reach than previous legislation, and it may affect even more contracts than the labor legislation does. Not only does the Act import certain terms into credit agreements, but it also prevents parties from agreeing to exclude any common law rights that would otherwise be applicable. The Act also specifically prohibits exemption clauses that relate to any guarantee or warranty that should, in the absence of such provisions, be implied in a credit agreement. This, for example, items sold on credit may not be sold footstoots, as the parties may not exclude the seller's implied warranty against latent defects. Should they purport to exclude such liability, their exclusion clause will be void. These are examples of the legislature stepping in to create protection where there was previously very little. By way of contrast, there is an instance where Parliament has done away with a common law provision in favour of parties once regarded as weak and worthy of protection. According to our common law, a woman who had agreed to stand surety for a debtor could bar any action brought against her by the creditor by means of an exceptio. In 1971, the Suretyship Amendment Act abolished this defense, recognizing that women were as capable as men of assessing the risks involved in contracts of suretyship. Recent legislation reflects the policies and priorities of the present government, such as provision of housing. The Rental Housing Act grants rights and imposes duties on landlords and tenants who conclude domestic leases. To some extent, these provisions give expression to the parties' constitutional rights. The Act also seeks to provide the tenant, who is typically regarded as the party with weaker bargaining power, with more extensive protection than that afforded by the common law. For example, the landlord is required to invest the tenant's deposit in an interest-bearing account and pay the interest to the tenant. To give detailed receipts to the tenant in respect of all payments and to refund the deposit within 7 days, or after deduction within 21 days of termination of the lease. However, the Act does not ignore or override the interest of the landlord, as this would deter owners from making their property available for rent. The Act seeks to find a fair compromise between the interests of both parties, just as parties may generally agree to exclude terms implied by the common law. They may exclude statutory terms by agreement. But certain provisions, such as the rule that the tenant's deposit must be invested, are, however, deemed to be so important that the parties may not exclude them by agreement. We have yet to feel the impact of the most expansive legislative incursion into the law of contract so far. The Consumer Protection Act, which has a very wide scope of application, will further limit parties' freedom of contract by creating a whole set of new implied terms, as well as reducing the circumstances in which the parties may exclude such terms and others recognized by the common law. And then there's a pause for reflection. Is an implied term just a rule of law applicable to a particular class of contract? In Alfred McAlpine and Son Proprietary Limited versus Transvaal Provincial Administration, Corbett stated, "The implied term is essentially a standardized one, amounting to a rule of law which the court will apply unless validly excluded by the contract itself. While it may have originated partly in the contractual intention, often other factors such as legal policy will have contributed to its creation." Similarly, according to Harms, a natural is a rule of law that can be varied or made inapplicable by agreement. Yet, for example, Chapter 3 of the Rental Housing Act distinguishes between general provisions that regulate the relationship between the landlord and the tenant in Section 4 and terms that will be deemed to be part of the lease in Section 5, subsection 3. Is there any theoretical or practical difference between a term implied by law and a rule of law that is applicable to a particular class of contract? Number 10.3.3.2. Terms implied ex consenso. Ex consensu, that is tacit terms. A tacit term is one that the parties did not specifically agree upon, but which, without anything being said, both or all of them expected to form part of their oral or written agreement. It is a wordless understanding, an unarticulated term having the same legal effect as an express term. Tacit terms are established by considering the express terms and the circumstances that surround the genesis of the contract. Some cases have suggested that the court may also have regard to the subsequent conduct of the parties. In ascertaining whether a contract contains a tacit term, the court often employs the officious bystander test. The court supposes that an impartial bystander had been present when the parties concluded their agreement, and had asked the parties what would happen in a situation that they did not foresee and for which their express agreement consequently did not provide. If they were to agree that the answer to the stranger's question was self-evident, they are taken to have meant to incorporate the term in their contract and to have tacitly agreed upon it. This applies not only to terms that the parties thought about but found unnecessary to incorporate into the contract, but also to terms that they would have incorporated if they had thought about them. A tacit term may therefore express not only the parties' actual intention, but also what they may be presumed to have intended, that is, an imputed intention. In deciding whether a tacit term is to be imported into a contract, two things are necessary. Firstly, it is obvious that the term sought to be imported must not conflict with an unambiguous express term of the agreement. A tacit term, after all, only supplements the contract by providing a term that the parties failed to agree upon expressly. That a tacit term can only be imported into a contract if it is necessary in a business sense to give efficacy to the contract was decided by Scruton in Reigate versus Union Manufacturing, Ramsbottom. This business efficiency test has been constantly applied by our courts. The implication must be necessary and not merely reasonable or convenient, and much will depend on the express terms of the agreement and the surrounding circumstances at the time it was entered into. Secondly, the term must be capable of clear and exact formulation. It must be as such, in the words of Coleman, in Technipark Sales Proprietary Limited versus Hall, would have evoked a prompt and unanimous assertion of the term which was to govern the situation. The classic test for importation of a tacit term are objective tests. In 711 Corporation of SA Proprietary Limited versus Kunkin Trading number 150 CC, however, the Supreme Court of Appeal hinted that it might be prepared to consider the subjective intentions of the parties at the time of contracting, rather than merely relying on objective criteria. A fertile field for the importation of tacit terms is trade usage. If the parties are engaged in a particular trade and they know that there is a trade usage governing their transaction, they are taken to have tacitly incorporated it into their contract. If one of the parties knows of the trade usage but the other does not, the latter may still be bound if the trade usage is shown to be uniformly and universally observed within the trade concerned. Notorious, reasonable, and certain, please forgive me, and does not conflict with positive law, or with the clear provision of the contract. In a case like this, the ignorant party would not in fact have agreed to the term imported by the custom, but he or she is taken to have done so if he or she led the other party reasonably to believe that he or she was aware of the well-known term and meant to contract subject to it. This is clearly an application of the general test for creation of a contract based on reasonable reliance. Number 10.3.4 Material terms. Terms in contract do not all carry the same weight. Those that are vital to the performance of obligations to be performed are called material terms. A material term is one that gives an aggrieved party the right to cancel the contract if it is breached, one that goes to the roots of the contract. If a term is considered to be of less importance to the performance of a contract, it is said to be a non-material term. For breach of a non-material term and in the absence of a cancellation clause, an aggrieved party can only claim damages. Then there's a small pause for reflection. Consider some examples of non-material terms. Payment and delivery terms are ordinarily regarded as non-material terms. It is said that they are not of the essence of a contract. A party faced with late delivery, for example, may not cancel a contract without having warned the defaulter that he or she intends to do so and without giving the defaulter a reasonable time in which to deliver. Similarly, a supplier may not simply cancel a contract if late payment is made for goods that he or she delivered. He or she is obliged first to demand payment. Only then may he or she cancel and claim return of his or her goods. Number 10.3.5 Conditions and their effects on the contract. Apart from the terms of a contract stating the rights and duties of the parties, there are provisions known as conditions. The word condition is often used loosely as a synonym for term. More accurately, it is a term that qualifies a contractual obligation in such a manner as to make its operation and consequences dependent on whether an uncertain future event will happen or will not happen. They differ from other terms in as much as they do not confer rights or impose duties with regard to performance of the contract, and their fulfillment is not enforceable. They merely express the parties' agreement on what is to happen to the obligations in the contract on the occurrence of an uncertain future event. The crucial question is whether an uncertain event will occur and not when it will occur. Number 10.3.5.1 Negative and positive conditions. Conditions may be positive or negative. A positive condition, also called an affirmative condition, depends on the happening of an uncertain future event. For example, I will pay your university fees next year if you pass all of this year's examinations. The condition will be fulfilled if the event occurs, that is, if you pass all of this year's examinations. A negative condition, on the other hand, depends on a future uncertain event not happening. For example, I will pay your university fees next year provided that I am not dismissed from my job before the due date. The condition is fulfilled when it becomes certain that the event cannot occur. In other words, the condition will be fulfilled if, when next year's fees fall due, the relevant contracting party has not been dismissed. Number 10.3.5.2 Suspensive and resolutive conditions. Conditions may also be classified as suspensive or resolutive. This classification relates to the effect of the condition on the operation of the obligation, or of the contract as a whole. The parties may agree that the performance of obligations under the contract will not be enforceable until it is known whether the condition, which must relate to an uncertain future event, has been fulfilled or has failed. If they have done this, they have agreed on a suspensive condition, also known as a condition precedent. For example, A agrees to buy B's immovable property provided that planning permission is granted by the local authority. Both of the examples mentioned in the previous section are also suspensive conditions. The operation of the obligation to pay your university fees is suspended until you pass all of this year's examinations, or until next year's fees fall due, without the relevant parties having been dismissed. Suspensive conditions can thus be either positive or negative, depending on whether the event in question must happen or not happen. It should be noted that a suspensive condition suspends the operation of the obligation and not the obligation itself. The obligation comes into being upon conclusion of the contract, but cannot be performed or enforced until the condition is fulfilled. The fulfillment or non-fulfillment of the condition has retroactive effect. In other words, if the condition is fulfilled, it is as if the obligation or contract, if the whole contract is subject to the condition, had always been operative. If, on the other hand, the condition is not fulfilled, it is as if the obligation or contract, as the case may be, had never come into being. It will thus be regarded as being void ab initio. Pending fulfillment or non-fulfillment of a conditional right is created. This may be ceded or be secured by way of suretyship. As it may have monetary value, it constitutes an asset in the holder's estate. It may thus be transmitted on death, and it will be regarded as an asset for the purposes of insolvency. If the parties agree that obligations under a contract should operate in full but will come to an end if an uncertain future event does or does not happen, they are said to have agreed to a resolutive condition, or a condition subsequent. For example, a student is granted funding for her entire degree, but this is dependent on her not failing any of her examinations. The funding body must perform in terms of this obligation, and if it fails to do so, the student may enforce performance. If the student fails an examination, however, the funding will be discontinued. As the condition has been fulfilled, the contract will come to an end. Again, the effect is retroactive, so the obligation will be treated as being void ab initio. Like suspensive conditions, resolutive conditions can be either positive or negative. Potestative, casual, and mixed conditions. Finally, conditions may be potestative, casual, or mixed. Fulfillment of a potestative condition depends on the potential creditor's doing or not doing something that is entirely within his or her power. For example, a motor car dealer might agree to donate a car to a golfer who hits a hole-in-one in a golfing competition. Parties who agree that the fulfillment of a condition depends on something beyond their control agree to a casual condition. If a lessor and lessee agree that the rent will be increased if municipal rates are increased, they would thus have agreed to a casual condition. Fulfillment of a mixed condition, on the other hand, depends partly on the creditor's actions and partly on the events beyond the control of both parties. For example, a wealthy uncle agrees to buy his niece a car if she obtains her driver's license. Fulfillment of the condition would depend partly on her own efforts and partly on events beyond the party's control, such as an appointment at the relevant traffic department becoming available. Number 10.3.5.4 Interference in the fulfillment of conditions. Contracting parties are generally not allowed to interfere deliberately in the fulfillment or non-fulfillment of a condition, whether suspensive or resolutive. Should a party do so, the condition is deemed to have been fulfilled, or not fulfilled, as the case may be. This is according to the doctrine of fictional fulfillment of a condition. In the words of Holmes, in Scott versus Popard, where a party to a contract in breach of his duty prevents the fulfillment of a condition upon the happening of which he would become bound in obligation, and does so with the intention of frustrating it, the unfulfilled condition will be deemed to have been fulfilled against him. Number 10.3.6 Time clauses. Unless agreed otherwise, performance is due immediately. A time clause postpones or fixes the date for performance. A time clause, this, or this a contractual term that makes the existence of an obligation dependent on an event or time that is certain to arise in the future. In this sense, a time clause differs from a condition, which relates to an uncertain future event. However, like a condition, a time clause may be suspensive or resolutive. With a suspensive time clause, the relevant obligations under the contract come into existence upon conclusion of the contract, but the operation is postponed. For example, a borrower is obliged to repay a loan, but the operation of this obligation is suspended until a specified date. With a resolutive time clause, the obligations terminate at the certain date or on the happening of a certain future event. Thus, a divorced couple may contractually agree that the husband will pay the wife maintenance for a number of years after their divorce, but that his obligation will fall away on a particular date. Number 10.3.7. Other common contractual terms. Some other contractual terms worthy of mention are suppositions, modal clauses, exemption clauses, and non-variation clauses. Number 10.3.7.1. Suppositions. Parties may decide to conclude a contract on the supposition or assumption that a certain state of affairs exists or existed. Thus, a second-hand copy of the third edition of a textbook might be offered for sale. A student who needs a copy for one of his or her courses is interested in purchasing the book, but only wants to buy it if it is the latest edition. If neither the student nor the seller knows whether it is the latest edition, they may contract on the basis that it is indeed the newest edition. If it turns out that there is a later edition, the supposition is false and the contract will be void. If, on the other hand, it is the latest edition, the contract will be valid. A supposition or assumption must be shared by both parties in order to form the basis for the contract. In other words, it must amount to a term of the contract. If only one of the parties has the supposition in mind, it will be legally irrelevant and tantamount to an error in motive. At first sight, a supposition seems similar to a condition. It is true that both may be either express or tacit, and both make the effects of a contract depend on something that actually is uncertain. The difference is that a condition relates to a future uncertain event, whereas a supposition relates to a past or present state of affairs. Number 10.3.7.2. Modal clauses. A modal clause, or modus, is a term that charges the recipient of a performance with a duty to do something in the future. This, for example, if someone makes a donation of land subject to a modus that the land is to be used for a school and the recipient builds a block of flats on the land, the recipient will have breached the modus. The obligation comes into being upon conclusion of the contract, and failure to comply with a modal clause constitutes breach of contract, for which the usual principles relating to breach apply. Number 10.3.7.3. Exemption clauses. Exemption clauses or exclusion clauses or disclaimers are terms that exempt a party from liability that would otherwise be imposed upon him or her. Thus, for example, a hotel might exclude liability for loss or theft of its guests' property. Exemption clauses are dealt with elsewhere in this chapter and the next. Here, it suffices to say that exemption clauses are valid and enforceable except where, for example, they purport to exclude liability for fraud or for injury caused intentionally. Number 10.3.7.4. Non-variation clauses. A non-variation clause is a term in a written contract that specifies that the parties may not vary the terms of their contract by agreement at all, or more usually that they may only do so in writing. Such clauses are valid and enforceable, and therefore, if a contract is varied orally, the variation will generally have no legal effect. For example, where a lease contains a non-variation term, the tenants may not rely on an oral variation of the terms relating to the payment of rent. Non-variation clauses are dealt with in more detail in Chapter 6. Number 10.3.7.5. Governing law clauses. A governing law clause is a term that purports to regulate which system of law will govern the legal relationship of the parties under the contract. Such clauses are commonly encountered in agreements that contain a foreign element, for example, where the parties are from different countries, and are generally valid and enforceable. This freedom to choose the governing law is not without limits, however. It extends only to the law governing the intrinsic validity, effect, and interpretation of the contract. Questions of contractual capacity, formal validity, and legality are determined by the objectively applicable law. Nor does it permit the parties to evade a mandatory provision of the law with which the contract has its closest and most real connection. For example, a provision of the Consumer Protection Act, if that act applies to the contract in question. In the absence of such a choice of law by the parties, whether express or tacit, the contract will be governed by the legal system with which, objectively, it has the closest and most real connection. PVL 3702, Law of Contract, Chapter 11, Interpretation of Contracts. Number 11.1, Introduction. Having established what the terms of a contract are, the next step is to determine what they mean. The ultimate aim of interpretation of a contract is to give effect to the intentions of the parties, or the purpose of the contract. Interpretation of written contracts is of great practical importance, given that many contractual disputes concern the meaning of their terms. It is often as difficult to interpret an oral contract as it is to determine the meaning of one that is in written form. However, since oral contracts are usually less complex and comprehensive than written contracts, they may be left aside on the understanding that those rules of interpretation can be made applicable to them apply in equal measure. For a number of years, the Supreme Court of Appeal has sought to bring clarity on the South African law of interpretation. The approach now favored by the court was crisply summarized in two cases: Natal Joint Municipal Pension Fund versus Indumeni Municipality, which dealt with interpretation of documents generally, and Botma Batu Transport EDMS PPK versus S Botma Insean Transport EDMS PPK, which dealt with interpretation of contracts. In short, said the court, interpretation is the process of attributing meaning to the words used in a document, having regard to the context provided by reading the particular provision or provisions in the light of the document as a whole and the circumstances attendant upon its coming into existence. Whatever the nature of the document, consideration must be given to the language used in the light of the ordinary rules of grammar and syntax, the context in which the provision appears, the apparent purpose to which it is directed, and the material known to those responsible for its production. In what follows, we shall take a closer look at each of these factors, bearing always in mind that the Supreme Court of Appeal has emphasized that interpretation is a unitary rather than a step-by-step process. Which of these factors predominates will vary from case to case, and the court may consider them in whatever order seems appropriate in the circumstances. Number 11.2. The purpose of the contract. In today's complex world, it is no longer accurate, if it ever was, to state that the purpose of interpreting a contract is to give effect to the common intention of the parties. That is to say, to what both of them intended upon entering into the contract. Although this formulation has the merit of reminding courts that the process of interpretation requires them to ascertain the meaning of the words chosen by the parties and not to impose their own views of what it would have been sensible for the contractants to say, the Supreme Court of Appeal says that the phrase should not be used if it is intended to suggest that the courts should embark on an investigation into the subjective intentions of the parties. The court pointed out that it is artificial to seek the common intention of the parties, whose contractual purposes have been filtered through the language hammered out in negotiations between legal advisors, in the light of instructions from clients as to their aims and financial advice from accountants or tax advisors, or are embodied in standard form agreements and imposed as the terms on which the more powerful contracting party will conclude an agreement. The Supreme Court of Appeal therefore emphasized that the inquiry should not go beyond ascertaining the meaning of the language of the provision itself. The approach to be followed is an objective one. Number 11.3. The language used by the parties having regard to ordinary rules of grammar and syntax. In the process of giving meaning to a contract, the beginning and end must always be the words in which the parties expressed their agreement. Traditionally, there were two approaches outlined by Schreiner in Jaga versus Dongas NO, Bana versus Dongas NO. Please forgive my pronunciation. The first required the interpreter to start with a clear ordinary meaning of the words, only subsequently referring to their context in cases of ambiguity. This approach was based on the assumption that language rests on the conventional basis and that parties acquainted with the conventional meaning of words will, in order to make themselves understood, use them accordingly. Few words have only one meaning, however, and the meaning of words is not immutable. Dictionary or everyday meanings, therefore, cannot be conclusive, and where the interpretation of a contract has become an issue before a court, it is often precisely because the parties attribute different meanings to the same word or phrase. The second approach identified by Schreiner was from the beginning to consider the context and the language to be interpreted together. Acknowledging that the appropriate meaning of a particular word or phrase can really only be ascertained by examining the context in which it has been used, the Supreme Court of Appeal has now clearly stated that this is the proper approach. This, says the court, is how people use and understand language, and it is sensible, more transparent, and conduces to greater clarity about the task of interpretation for courts to do the same. Number 11.4. The textual context. In giving an appropriate meaning to the disputed term or terms of the contract, the court must interpret the wording in the context of the other provisions of the document. This was referred to as linguistic treatment by Schreiner in the seminal case of Dalmas Mining Co. Limited versus Duplessis. Words ought to be interpreted in their contextual setting to give effect to a contract, rather than to make it ineffectual. If, therefore, the ordinary or narrow meaning of the word results in some absurdity, some repugnancy, or inconsistency with the rest of the instrument, the ordinary meaning will yield to a broader or less immediately apparent meaning that is consistent with the rest of the contract. And it should be added, an interpretation favoring validity, practicality, and business efficiency should be preferred to one that does not. Judges must, however, be alert to and guard against the temptation to substitute what they regard as reasonable, sensible, or businesslike for the words actually used. To do so in a contractual context is to make a contract for the parties other than the one they in fact made. Number 11.5. The broader context. Intratextual treatment may not clearly yield up an appropriate meaning, so the interpreter may also consider extratextual elements, the extended context, so as to be able to draw useful inferences as to the intended meaning from the nature of the contract, its purpose, and the background against which the contract was concluded. However, if parties were allowed to adduce any evidence they liked, the purpose of reducing the contract to writing, such as certainty and prevention of litigation, would be undermined. It was in the search for a sensible middle way that our law adopted the parole evidence rule. Number 11.5.1. The parole evidence rule. The rule regarding admission of evidence on matters outside the contract that throws light on how it is to be interpreted is a rule of great technical complexity received into our law from English law. The parole evidence rule declares that where the parties intended their agreement to be fully and finally embodied in writing, evidence to contradict, vary, add to, or subtract from the terms of the writing is inadmissible. As an evidentiary rule, the parole evidence is subject to the fundamental principle governing the admissibility of all evidence, namely that irrelevant evidence is inadmissible. This fundamental rule explains much of the sometimes complex doctrine that the courts have construed over the years regarding the content and interpretation of written contracts. The parole evidence rule manifests itself in two ways. Firstly, it determines what evidence is admissible to prove the contents of the contract, and in this guise it is known as the integration rule. Secondly, it determines what evidence is admissible in proving the meaning of the words used by the parties to express those terms, and in this regard it is known as the interpretation rule. The first aspect of the parole evidence rule thus regulates admissibility of evidence brought to answer the question, is this a term of the contract? The second is concerned with evidence brought to answer the question, what does this term mean? The two compartments are not watertight, and the distinction may be artificial. For example, in deciding whether a term is part of the contract, a judge cannot help but consider its meaning. Number 11.5.1.1. The integration aspect of the parole evidence rule. The reasoning behind the parole evidence rule is that the parties are said to have consolidated or integrated their earlier negotiations into one document, which is then to be taken as the final expression of their will. They should not be allowed to redefine the terms of their contract by reference to evidence that contradicts its terms. Such extrinsic evidence is regarded as legally irrelevant. The so-called integration rule thus defines the limits of the contract. It determines what evidence is admissible to prove which provisions are contained in the contract. The parole evidence rule is itself subject to certain limitations. It is thus not applicable where the very question before the court is whether or not the parties intended to draw up an exclusive memorial of their agreement. A party wishing to lead evidence that the written document does not reflect the whole of an agreement is therefore free to establish that it does not do so because it was intended to be part of a larger transaction involving a condition precedent to its operation, or that, although ostensibly contracting as principal, the party in reality contracted as agent on behalf of an undisclosed principal. Nothing prevents parties from concluding one part of an agreement orally and another part in writing. The integration rule obviously does not apply to an oral part of the agreement that the parties did not intend to be embodied in writing. That is, where there has been only partial integration. Evidence of the oral agreement, which would usually be an adjunct to the main or dominant agreement, is nevertheless not permitted where it would contradict the terms of the written agreement, or where it deals in an inconsistent manner with the topic dealt with in the written agreement. In a case like this, the written agreement may be conclusive. The rule also does not operate where an aggrieved party alleges fraud, misrepresentation, mistake, undue influence, duress, or illegality. In these cases, the question is not the true construction of a term or terms of the contract, but the contract's validity. Similarly, and also going to validity, an aggrieved party may always prove that what appears to be a written agreement is not an agreement at all, or that it is a sham agreement that does not record the true agreement between the parties. Evidence of a subsequent oral agreement is clearly not excluded by the integration rule, but may be excluded by a clause found in many formal contracts, the so-called non-variation clause, which provides that no variation of a written contract is to have effect unless reduced to writing. Such a term is, in the absence of fraud, binding upon the parties and also prevents an oral waiver of a written term if the clause entrenches both itself and all the other terms of the contract against oral variation. The integration rule does not apply to a document signed by only one of the parties, but it does govern the admissibility of evidence in the case of instruments like negotiable instruments. They are a good illustration of the inadmissibility of a prior or contemporaneous oral agreement where such an agreement contradicts the terms of the written instrument. A negotiable instrument is intended to incorporate an unconditional obligation so that evidence of another agreement that a party should not be bound is inadmissible. Evidence that the operation of a negotiable instrument has, by an extrinsic agreement, been suspended is admissible on the basis that it does not flatly contradict the terms of the written agreement. Number 11.5.1.2. The interpretation aspect of the parole evidence rule. The second aspect of the parole evidence rule, the interpretation rule, controls the kind of evidence that may be led to establish the meaning of the contractual provisions. It determines when and to what extent extrinsic evidence may be adduced to explain or affect the meaning of the words contained in a written contract. The locus classicus on the interpretation rule, as it was applied in the context, was the decision of the Appellate Division in Dalmas Milling Co. Limited versus Duplessis. The principles of interpretation laid down in that case were derived from an application of the relevance rule governing the admissibility of all evidential material. If the meaning of a contract could be ascertained with sufficient certainty from the written words, evidence of matters outside the contract were irrelevant. The court would therefore not be entitled to take them into account. The rule was qualified to this extent. No matter how clear the words of a contract were, they still had to be applied to extraneous facts. For example, if it was disputed that the plaintiff was the seller named in a contract, evidence identifying the seller could be tendered. In giving meaning to a troublesome contract, some reference to the extra textual context is usually necessary. In order to limit the circumstances in which extrinsic evidence could be brought, our courts traditionally made a distinction between evidence of background circumstances, which was admissible as a matter of course, and evidence of surrounding circumstances, which was only admissible in cases of ambiguity. This distinction, however, proved itself to be more of a hindrance than a help, as it was never clear precisely how contextual circumstances were regarded as background and which as surrounding circumstances. Number 11.5.1.3. Practical difficulties in excluding extrinsic evidence. The open sesame of uncertainty. The conventional wisdom, until fairly recently, was that courts would only admit evidence of surrounding evidence where the wording of the document was ambiguous, and such ambiguity or uncertainty could not be dispelled by reference to the rest of the document and to the background circumstances. Over the years, our courts became more and more willing to take into account the broad context in which the contract came into existence, whether or not the wording of the contract was clear. In theory, the interpretation aspect of the parole evidence rule was simple. If the meaning of the contract on its wording was clear, any other evidence in that regard would be irrelevant. However, it is seldom possible for a court to determine finally the meaning of a contract before all parties have presented their evidence and made their submissions on the meaning of the contract. When evidence concerning the conclusion of a contract was tendered in court, it was impossible for a judge to rule evidence of the broader context inadmissible without first having come to the conclusion that the contract was clear enough not to require such evidence. This was a judgment call that a court could not make without having regard to the evidence and contentions of the opposing party. There was therefore a natural tendency to allow all evidence to be brought before the court. This practice entirely defeated the object of the parole evidence rule, which was to exclude such evidence. As relevance could not be determined before the end of the case, when the evidential material from all sides had been received, the theoretical division of the interpretational inquiry into stages, first examining the ordinary meaning of the word, then looking at its context, and then deciding whether extrinsic evidence might be useful as an aid to interpretation, was hardly a practical exercise. This led the Supreme Court of Appeals finding that any pretense that at following a staged approach should be abandoned in favor of a unitary process of interpretation. As a consequence, it is no longer even theoretically necessary to prove that a contract is ambiguous before considering its broader extra-textual context. This accords with the views of the Law Commission, which in its proposal for the draft bill on unreasonable contractual terms and rectification of contracts recommended that the following provision be included in the proposed bill. Whether or not the words of the contract appear to be ambiguous evidence of what passed during negotiations between the parties during and after the execution of the contract and surrounding circumstances is admissible to assist the interpretation of any contract. It should be noted, however, that this bill has never been translated into legislation, and the Supreme Court of Appeal has recently reaffirmed that evidence of prior negotiations remains inadmissible. Number 11.5.1.4. Practical and theoretical difficulties in excluding extrinsic evidence. The distinction between background circumstances and surrounding circumstances. Even where, as is usual in such litigation, the contract before the court was indeed ambiguous and evidence of surrounding circumstances was therefore admissible, there was another practical hurdle to overcome. It was unclear what was meant by surrounding circumstances. For example, in Coopers and Leibrand versus Bryant, the court included in surrounding circumstances, previous negotiations and correspondence between the parties, and subsequent conduct of the parties showing the sense in which they acted on the document, but not direct evidence of their own intentions. This was problematic since whatever the parties negotiated about must inevitably have been presented to their minds at the time of concluding the contract. How was it possible for a litigant to give evidence of his or her negotiations with another without indicating what he or she intended the negotiations to achieve? This may be compared with the statement of Schreiner in Dalmas Milling Co. Limited versus Duplessis that surrounding circumstances specifically excluded actual negotiations and similar statements. The same vagueness and ineffectiveness bedeviled the definition of background circumstances, so that in the end no one knew precisely what the dividing line between the two categories were, or was. The imprecision of the definitions made it hazardous for a judge conducting a trial to exclude evidence from consideration, particularly since this would have to be done at an interim stage of the proceedings, and it was impossibly risky for a litigant to take the position that some evidence thought to be useful should not be tendered because it was potentially inadmissible. An evidentiary system of such remarkable imprecision could only have survived if, as Harms remarked in KPMG Chartered Accountants SA versus Securefin Limited, it was widely ignored by trial courts. Number 11.5.1.5. A new approach to extrinsic evidence. In view of the practical difficulties outlined above and the difficulty of drawing a workable or even an intelligible distinction between background circumstances and surrounding circumstances, it was unsurprising when the Supreme Court of Appeal finally held that the broader context should be considered, whether or not the contract was ambiguous on the face of it, and abandoned whatever distinction there may have been between background and surrounding circumstances. Speaking for a unanimous court, Wallis stated in Botma Batu Transport EDM SBPK versus S. Botma Insean Transport EDM SBPK. Whilst the starting point remains the words of the document, which are the only relevant medium through which the parties have expressed their contractual intentions, the process of interpretation does not stop at a perceived literal meaning of those words, but considers them in the light of all relevant and admissible context, including the circumstances in which the document came into being. The former distinction between permissible background and surrounding circumstances, never very clear, has fallen away. This, of course, begs the question, what is the relevant and admissible context? It is apparently broader than merely the circumstances attendant upon the contract's coming into existence. Is it intended to sanction the admissibility of evidence that would not previously have been permissible, even under the broad rubric of surrounding circumstances? Or is the intention only to assimilate the two categories of background and surrounding circumstances, and not to allow evidence that would have been inadmissible under the earlier regime? If one argues that the subjective intention of the parties forms part of the factual matrix, and that this amounts to the context of the contract, would this then imply that, contrary to previous practice, direct evidence of the intention could be led? Have the courts opened their doors to an overwhelming flood of documentary and other evidence? Has the interpretation aspect of the parole evidence rule fallen away altogether? At first sight, although the Supreme Court of Appeal has affirmed that the parole evidence rule still forms part of our law, it seems that, at least in its interpretation aspect, it has no role to play. This is not so, however. The court has merely taken us back to a basic rule of evidence. The touchstone of admissibility is relevance. The fact that contextual evidence that is relevant will remain inadmissible should discourage parties from flooding the courts with unnecessary evidentiary material. In addition, Harms sounded a warning in KPMG Chartered Accountants SA versus Securefin Limited, to the extent that evidence may be admissible to establish its factual matrix on purpose or for purposes of identification, one must use it as conservatively as possible. In certain respects, the court does appear to have cast the net of admissibility more widely than under the previous law. For example, it has been held that evidence of the parties' subsequent conduct is now admissible. Also, it seems at first that the court's new approach might have opened the door to a relaxation of one of the restrictions previously opposed by the parole evidence rule, namely that evidence of the parties' subjective intention did not fall within the bounds of evidence of surrounding circumstances. Even though the hidden intentions of a party may logically be relevant in explaining why he or she chose certain words to express his or her meaning, direct evidence by a party of what he or she intended was always inadmissible. There were good policy reasons for this. If this kind of evidence were to be admitted, it would mean exhuming all the dead issues that the parties had considered and then discarded in their negotiations, so that the certainty that a written contract is meant to produce would be completely lost, and disputes on the interpretation of a contract might become interminable. Libber and Murray neatly formulate the difficulties that may arise from such an overextensive approach. From such a perspective, considerations of legal policy, the traditional view of the parole evidence rule in the present context becomes intelligible. It seeks to protect judges against intractable disputes of fact regarding subjective states of mind and the concomitant risk of fraud and perjury that will undoubtedly arise should parties be entitled to resort freely to extrinsic evidence during the process of interpretation. The consideration that fraud is to be discouraged and that the duration and costs of litigation should be restricted as far as possible is a normative one which militates against an approach that seeks the true intention of the parties at any price. It was therefore to be expected that the court would still not admit direct evidence of the parties' intentions, and indeed the Supreme Court of Appeal has recently reaffirmed that such evidence remains inadmissible. Interestingly, in Natal Joint Municipal Pension Fund and in Dumeni Municipality, the court also seemed to provide another route to the same destination. Instead of using the parole evidence rule to prevent parties from circumventing their written contract by leading evidence of their subjective intentions, the court emphasizes that the process of interpretation is an objective one, that does not involve an inquiry into the minds of the contracting parties. In interpreting a contract, the court is concerned with what an objective bystander would understand the parties to have agreed, not with what they have subjectively intended. What is relevant is the parties' express intention rather than their subjective consensus. Number 11.5.2. Circumventing the parole evidence rule. A litigant who is confronted with difficulties of proof thrown up by the parole evidence rule has always potentially been able to circumvent it, either by alleging a tacit term or by including a claim for rectification. Number 11.5.2.1. Alleging a tacit term. The restricted scope of the interpretation rule becomes clear when one considers that a party who seeks to attribute a certain meaning to a written contract may lead evidence extraneous to the contract to show that the contract contained one or more tacit terms. They may either be terms that the parties envisaged but neglected to include in the contract, or terms that are so essential to the commercial viability of the contract that the parties would inevitably have inserted them into the contract had they thought about them. From a practical point of view, a party who is confronted with the unpalatable content of a perfectly clear document may allege and attempt to prove a tacit term in the contract. A tacit term that flatly contradicts a written one may not be proved, but the field is wide open to a litigant to allege a tacit term that qualifies or in some other way modifies a written term. Once an investigation into the scope of a tacit term gets underway, all the types of evidence that are excluded by the parole evidence rule are let in. Admittedly, this happens for a different purpose from that of interpreting a written term of the contract, but the evidence still features before the court, which will be hard put to ignore if the evidence appears persuasive. Number 11.5.2.2. Applying for rectification. Another device that is commonly resorted to when the rules of interpretation get in the way is the rectification doctrine. A party who alleges that the parties mistakenly inserted a term into a written contract or that they mistakenly failed to include one in it may apply for rectification of the mistakenly concluded contract. Once a claim for rectification is made, all evidence that is relevant to demonstrate that the parties included a wrong term or intended but neglected to include a certain term becomes admissible. Since evidence otherwise excluded by the integration rule becomes admissible once there is a claim for rectification of the contract, a written contract may be rectified in such a way that a conflict between it and an earlier oral agreement is eliminated, so that in this way enforcement of the earlier agreement becomes possible. A litigant seeking to establish before a court the meaning of a clause would therefore be well advised to include in his or her claim an alternative of rectification. Even if the claim for rectification should fail, then on some technical basis, a court that has been convinced by the evidence that the agreement before it does not correctly reflect the intention of the parties is unlikely to hold, because of the technical intricacies of the integration rule, that the evidence is to be disregarded and that the agreement, known to be wrong, should be upheld as the correct agreement. Okay, and then there's a counterpoint. Is rectification an exception to the integration aspect of the parole evidence rule? A contracting party who alleges that a document does not reflect the true agreement reached by the parties may claim rectification of the document. He or she must then convince the court that as a result of error or mistake, the document fails to reflect the common intentions of the parties, and he or she must provide the court with a formulation that reflects this common intention. Rectification is not, as has been suggested, an exception to the parole evidence rule. The integration rule supposes that the parties managed properly to consolidate the outcome of all their, sometimes complex and lengthy negotiations into one document. It is for this reason that evidence of terms outside the document is held to be inadmissible. The rectification doctrine supposes that the parties did not manage properly and fully to integrate their agreement. The interpretation rules suppose that the contract is what it purports to be and that it only remains to discover what it means. In a rectification claim, the very issue is that the contract is not what it seems on paper to be, so that evidence of what it really is becomes not only admissible but essential. The courts have gone so far as to hold that although there was no mistake in the writing, the mistaken belief of the parties that a prior or contemporaneous undertaking deliberately not recorded in the document would apply concurrently with the document justified a claim for rectification. As in the case of Moten versus Hanacom, there was no mistake as to the terms of the agreement, which recorded exactly what the parties wished it to record. Number 11.6. Canons of construction. If, despite applying the above principles, the court is still unable to come to a conclusion as to the meaning of the contractual provisions, it may seek guidance from various canons of construction. These are guidelines aimed at assisting the court in interpreting a contract. There is no closed list of rules. More may be added, and a court is not required to apply all of them. Moreover, a court may apply these rules in any sequence. Some of these subsidiary rules overlap with the principles discussed above, and it remains to be seen whether they still have any relevance, given the current views of the Supreme Court of Appeal. For example, the Aestem generis rule, which stipulates that words with the general meaning are restricted when used in association with words relating to a species of a particular class, may be seen as a narrower expression of the general rule that words must be interpreted in the context of the contract as a whole. The same may be said of the rule that states that words are known or understood by the company they keep. Noscitur sociis. Several rather technical rules relate to the way in which a contract has been reduced to writing. For example, where a contract consists partly of print and partly of inserted typed or written words that are inconsistent with the printed text, effect is to be given to the written or typed insertions. Having been chosen by the parties, their words are taken to more accurately reflect the intention of the parties than a standardized text. Preambles to a contractual text are generally regarded as subordinate to the operative part of the contract if it is sufficiently clear. If not, the preamble may be used to clarify the contract terms. Other subsidiary rules are based on the presumed intention of contracting parties in general. For example, there is the rule that if a term is ambiguous, it should be given a meaning that would make it effective rather than one that would make it legally ineffective. Et res magis valiat quam periat. Please forgive my Latin. This is based on the assumption that the parties would not have intended to create a contract or a term that has no effect. The same sort of reasoning lies behind the rule that a court should be slow to conclude that words in a single document are tautologous and superfluous. Similarly, in the absence of clear evidence to the contrary, it may be assumed that parties intended their contract to be legal rather than illegal. This applies equally whether the potential illegality derives from the common law, statutes, or the Constitution. If, therefore, a term may be interpreted as being either constitutional or unconstitutional, the court should favor the interpretation that accords with the Constitution. As Marais stated in First National Bank of South Africa Limited versus Rosenblum, in the end, the answer must be found in the language of the clause read in the context of the agreement as a whole, in its commercial setting, and against the background of the common law, and now, with due regard to any possible constitutional implication. Finally, some of these subsidiary rules are aimed at achieving a fair result. As Brandt stated in South African Forestry Co. Limited versus York Timbers Limited, while a court is not entitled to superimpose on the clearly expressed intention of the parties its notion of fairness, the position is different when a contract is ambiguous. In such a case, the principle that all contracts are governed by good faith is applied, and the intention of the parties is determined on the basis that they negotiated in good faith. Thus, where the wording of a contract is ambiguous, the court will favor an equitable interpretation, on the assumption that this is what the parties would have intended. Finally, there are certain rules that are applied as a last resort without any pretense at attempting to find the expressed intention of the parties. The purpose of these rules is to provide a fair outcome, rather than to give effect to the parties' common intention or purpose as expressed in the document. One such rule is the contra preferentum rule, which states that the terms of a contract, if capable of more than one meaning, are to be interpreted against the party who proposed them, often an insurance company or perhaps a public utility. The rationale for this rule is that the party who should suffer from an adverse construction of a term is the one who could have made its meaning clear. The same sort of reasoning lies behind the quad minimum rule, which states that ambiguous words must be narrowly interpreted, so as to encumber the debtor or promisor as little as possible. And then there's a counterpoint. Consider an application of the contra preferentum rule. Reflect on the judgment of the Supreme Court of Appeal in Drifters Adventure Tours CC versus Hircock. Bearing in mind that the warning expressed in the same court in Durban's Water Wonderland Proprietary Limited versus Botha, that a court must not strain the meaning of the words in order to find ambiguity where there is none. In this case, an American tourist took part in an adventure tour conducted by Drifters Adventure Tours. She was injured in a vehicle accident caused by the negligence of an employee of the touring company while driving on a public road. The company sought to rely on an indemnity that stated, among other things, that the tourist absolved drifters, their staff and management and affiliates of any liability whatsoever, and that she undertook the tour entirely at her own risk. This indemnity clause appeared on the front of a form signed by the tourist. It expressly referred to conditions on the reverse of the form. One of these conditions stated, due to the nature of hiking, camping, touring, driving, and the general third world conditions on our tour or ventures, drifters, their employees, guides, and affiliates do not accept responsibility for any client in respect of any loss, injury, illness, damage, accident, fatality, delay, or inconvenience experienced from time of departure to time of return, or subsequent to date of return. Such loss, injury, etc., arising out of any such tour or venture organized by drifters. The court began by stating the contra proferendum rule. It went on to consider the ordinary meaning of the indemnity clause. It held that although the words any liability whatsoever, read in isolation, would cover liability for negligence, they had to be read in the context of the document as a whole, including the conditions on the reverse of the form. The court was of the view that the condition quoted above was not intended to cover liability for negligent driving on a public road, but was rather aimed at indemnifying the company for the kinds of risks encountered in off-road driving in exciting terrain. So, said the court, although it is possible to interpret the expression driving as referring to any kind of driving anywhere in the country and on any terrain, it is probably not the interpretation that a reasonable reader would give to it, and is, in the light of established canons of interpretation, not one we should favor. The court held that the word driving in this context was ambiguous. The court was prepared to consider the evidence of one of the founders of Drifters Adventure Tours as to the genesis of the indemnities. His evidence reinforced the court's opinion that the indemnity was not intended to cover loss or injury resulting from negligent driving on a public road. Finally, the court considered the touring company's insurance arrangements. These two convinced the court that it was correct to interpret driving narrowly. Do you agree that the word driving was ambiguous in the circumstances? Number 11.7. When all the rules of interpretation have been exhausted. As will be clear from this chapter, the courts go to great lengths to establish the meaning of a contract. If, however, it is unable to do so, the court will declare the contract void for vagueness. Number 11.8. Interpretation of disclaimers, indemnities, and exemption clauses. A special category? The approach of the courts to the interpretation of disclaimers, indemnities, and exemption clauses is clearly stated in Durban's Water Wonderland Proprietary Limited versus Botha. In this case, the respondent and her child sustained injuries by being thrown from a malfunctioning jet ride at an amusement park operated by the appellant. In response to the respondent's claim for damages, the appellant alleged that the respondent was contractually bound by a disclaimer displayed at its ticket booths. The disclaimer stated that the appellant was absolutely unable to accept liability or responsibility for injury or damage of any nature whatsoever, whether arising from negligence or any other cause, howsoever, which is suffered by any person who enters the premises and or uses the amenities provided. In considering the question whether the clause in question in fact exempted the appellant from liability for negligence, the court set out the rules of interpretation as they apply in this context. The correct approach is well established. If the language of a disclaimer or exemption clause is such that it exempts the proference from liability in express and unambiguous terms, effect must be given to that meaning. If there is ambiguity, the language must be construed against the proference. See Government of the Republic of South Africa versus Fibre Spinners and Weavers Proprietary Limited, 1978. But the alternative meaning upon which reliance is placed to demonstrate the ambiguity must be one to which the language is fairly susceptible. It must not be fanciful or remote. For reference, see Canada Steamship Lines Limited versus Regum, 1952. The court found that the wording of the clause clearly covered any liability based on negligence related to the design or manufacturer of the ride in question. The court disagreed with the quid pro quo that the phrase accept liability was ambiguous and could be taken to mean that the appellant would not admit liability, though it was open to someone in the position of the respondent to prove his or her claim in court. The appeal court held that such an interpretation would be far-fetched, that it would have resulted in the notices being futile, and that it would not necessarily have been in the interest of the appellant anyway. It accordingly held that the parties could not have intended that the words carry the alleged meaning. In conclusion, the court held that the wording was unambiguous and that it served to exempt the appellant from liability. This approach has been confirmed by the Supreme Court of Appeal in more recent cases. It is now generally accepted that such clauses must be interpreted in the usual way, applying the ordinary rules of construction. Where there is ambiguity as to the intentions of the parties, however, the word or phrase in question will be interpreted contra proferentum or contra stipularentum. In other words, an ambiguous exemption clause will be given an interpretation that least favors the party who inserted the clause. Ambiguity may thus be used to minimize the effect of an exemption clause by reducing the range of events covered that may cause loss, or to reduce the exempted legal grounds of responsibility for the damage suffered. In cases of ambiguity, therefore, the court may allow policy considerations to override the intentions of at least one of the parties. The court accepts an interpretation unfavorable to the profferent because he or she had the chance to express him or herself more clearly. The rule is only applied as a last resort, however, when other rules of construction have failed. Moreover, as was stressed in Durban's Water Wonderland Proprietary Limited versus Botha, the court must not adopt a strained or forced meaning in order to import some ambiguity into the wording of the clause. If an exemption clause clearly and unambiguously exempts a party from liability or indemnifies him or her against any loss, the court must give effect to it, even if its consequences are harsh, unless the provisions is so gratuitously harsh and oppressive that public policy could not tolerate it. Where there is no ambiguity, therefore, there is no room for the contra proferentum rule. While courts tend to approach exemption and indemnity clauses with circumspection and will generally try to construe them restrictively, they will respect the clearly stated intention of the parties unless the provision falls foul of the general rule that contractual terms must not conflict with public policy. Number 11.9. An objective approach to interpretation of contracts. For many years, the following dictum per Innes in Hubert versus Enslin was cited by our courts as an accurate expression of our law. The golden rule applicable to the interpretation of all contracts is to ascertain and to follow the intention of the parties, and if the contract itself or any evidence admissible under the circumstances affords a definite indication of the meaning of the contracting parties, then it seems to me that a court should always give effect to that meaning. It implied that our courts took a factual or historical psychological approach to interpretation, that is, one which seeks to establish the intention of the parties as a fact existing at the time of contracting. This would accord with the basically subjective approach of the rest of our law of contract and the consensual basis upon which it rests. It presented the courts with a paradox, however, for they had to establish the parties' subjective intentions, but they had to do this by referring to objective factors. This difference of approach was reflected by authors on the law of contracts. This Christie says, the key to understanding the modern law is the concept of the common intention of the parties, which may be a very different thing from the actual intention locked up in the mind of each party at the time of contracting, and even more different from what, after a dispute has arisen, each party honestly or dishonestly maintains his intention then to have been. For Christie, then, the intention of the parties meant the common stated intention of the parties. The inquiry must not be into what the parties had in mind, but to their common intention as expressed in the words of the contract. This can be compared with the views expressed by Kerr, who clearly supports a more subjective approach. Consider, for example, his reference to the adoption by some of the theory that a court is not concerned with the party's intention, only with what the words they chose mean to others who did not choose them and who did not make the contract. This is the most unacceptable theory of contract. Taking a more objective or a more subjective stance towards interpretation of written contracts influences the admissibility of evidence. If our law followed an approach that was entirely subjective, it would have to admit all evidence touching upon the intention of the parties, including the direct evidence of the parties themselves as to what their intentions were at the time of contracting. In other words, it would have to allow a contracting party to appear in court and explain what he or she meant by the words in the contract. If, on the other hand, our law followed an entirely objective approach, the only admissible evidence other than the document itself and its ordinary or grammatical meaning would be of an identificatory nature. The parole evidence rule would be strictly applied, and the parties' intention to make the written document the exclusive memorial of the agreement would take precedence over the subjective intentions that they aimed to express in that document. Our law seemed to be moving from a more objective approach to interpretation with a correspondingly restrictive attitude to admissibility of evidence to one that was more subjective, in that the court's more expansive attitude towards the admissibility of evidence could enable it to go further into the extra-textual context of the document in order to discover what the parties subjectively intended. In Natal Joint Municipal Pension Fund versus Ntumeni Municipality and Botma Party Transport EDMS BPK versus S Botma Insean Transport EDMS BPK, the Supreme Court of Appeal resolved the paradox mentioned above by refusing to inquire into the parties' subjective intentions at all, while admitting all other contextual evidence that may be relevant in determining what the parties' stated intention was. It seems, therefore, that one of the most fundamental rules in our law of contract is that the primary basis for a contract is the subjective meeting of the minds of the parties, is no longer of any relevance where the contract has been reduced to writing. What the parties appear to have agreed trumps whatever they may have subjectively agreed.